So a little bit of today will be review, because it's really been, has it been a week since we met, right? It was a snow day, yeah. And then you were also supposed to read the cases for today. But the cases are more for the standard, you know, and we're not going to go through the cases in the sense of briefing them. So what I'm thinking that I will do is we'll review and continue the conversation that we started last Tuesday about DCF, pre-court investigation, services as an administrative agency, and then it all, as it interlaps or coincides with the care and protection process. And along the way, we'll mention some of the cases that set standards for different things, like the burden of proof, visitation, etc. Okay? So we'll do it like that. And again, I apologize for bouncing around because it's the nature of both the process and the way the statute is laid out. So we'll start like we started before with a 51A. And so as I'm doing, actually, you know what? Let me start first just in general with, because I didn't talk about it at all other than telling you guys that the mission, the purpose, you know, as most statutes have, they usually have a purpose clause. And 119 has much more than a purpose clause. It has a purpose like page. 119 section 1 is 1, 2, 3, 4, 5, 6, like 6 paragraphs. So there's 119 section 1 that again is the purpose of any proceedings dealing with children in Massachusetts. And also the DCF regulations, the very first one is 1.01. Remember that I mentioned that you have the statute, which is Mass General Laws, Chapter 119, right? And actually, you know what? I'm going to put the regulations under DCF. And then DCF being an administrative agency, making its own regulations, right? They're contained in 110 CMR. And 110 CMR section 1.01 is the first one. And I don't know if the elder mentions it in the article that I gave you guys, but just to summarize this, it's one paragraph, and it talks about the Department of Children and Families' main policy. And you'll hear this over and over again. You'll hear it in case law, etc. Strengthen and encourage family life, so that every family can care and protect for its children. And notice care and protect coincides with, you know, what the name of the statute 119 is, the care and protection process. And again, I'm just summarizing from this regulation right now. And it says, the department also will make every reasonable effort, and you'll see that, note that down, reasonable efforts, because we'll talk about that, to encourage and assist families, give them resources to maintain their family unit. And right in that particular policy, there's a however. And it says, however, for so long as a family can't provide the necessary care and protection for its children, the department does what? Intervenes to protect the right of children to, you know, sound health, normal development, etc., to intervene. And these are called the dual obligations of DCF. Protect children on the one hand, right? But also strengthen and I'll say encourage family life. And sometimes they're at odds with each other. Dual obligations of DCF. Protect children and yet respect the rights of families to be free from this state intervention. It even says it in the regulations. It says it's a difficult balance to strike, but it's the defendant's mandate. So that's a summary of 1.01, the statement of philosophy of DCF's own philosophy contained in its own regulations. Now, you guys also have section 1 of the statute, which I'm not going to read you the whole thing. It's like a page and a half. But just the highlights of it, if you look at the Declaration of Policy Purpose, so Stephanie's back. You finished your training.
Yes.
Stephanie's been online for a while. She's working for DYFs now, or as a, not really particularly for DYFs, but
Yeah.
as a
Juvenile
yeah.
justice.
Yep. So, section 1, the policy of the Commonwealth, it says again, very similar to DCF's regulations, strengthening and encouraging family life, the care and protection of children. Further down, the test, and you'll see this a lot, it's the health of and safety of the child. So again, you have family life, help families, but at the same time, protect children, which could be, you know, together, but could be at odds with each other depending on the type of case that you have. So I wanted to mention that, and I didn't remember if we talked about section 1 or not. So, strong, just say strengthen, encourage family life, and protect children. So it's the same. So you're seeing it both in the regulation and in the statutes. That's section 1. So now let's just bounce back to 15.1a as we began talking about the process. A lot of this is review because we did talk about it a week ago. So if you have it, whether you have it on your laptops or if you printed out this section, let's take a look at 51A. And so I'm going to ask some of you guys questions. Okay. So purpose. Now let's look to reporting, right? You have to, if you describe to someone, Michael, what this particular section of Chapter 119, 51A is, what exactly is it?
It talks about the requirements for mandated reporters. If I remember right, there were sort of 3 different general sections. One was like educators.
You're mentioning the definition of mandated reporter, which, by the way, remember that was in our definitional section of 119 is section 21. So the definitions are
It was
different categories, as you said, education.
Healthcare providers.
Yep.
And then I think it was
Police, probation officers, court personnel, etc. And then lastly, clergy, religious people, with exception being if clergy heard it in the context of a confessional, it could possibly be an exception. But those are sort of the broad categories of mandated reporters. And there again, they're defined, the whole class is defined in section 21. So Michael is starting with if a mandated reporter is faced with what? What's the test?
It was, hang on, I got it here. Reasonable cause.
Magic language that we're going to see a lot. Reasonable cause to believe that what?
That abuse has occurred.
Abuse
physical or emotional abuse.
Abuse or what else? The 2 broad categories are abuse and... Somebody help me?
Neglect, yeah.
And remember, we said that these aren't defined in the statute. They're defined instead in the regulations. Okay? Abuse meaning non-accidental commission of an act that creates substantial risk of injury, and then neglect, we talked about deprivation of basic needs, etc. So those are contained in 110 CMR. I'll give you guys the sites. 110 CMR abuse is in the glossary. It's in 2.0 right at the beginning. And I think neglect is there as well. So what does reasonable cause mean, Sean? So in the context of someone who's a mandated reporter, a cop, a nurse, etc., if they have reasonable cause to believe, Michael just said that a child is suffering from abuse and neglect, they have to report to the department. What does reasonable cause mean?
It falls under the reasonable
person doctrine where any person in that situation would think that a child was suffering physical or emotional injury.
Are you reading from somewhere?
No.
Oh, no, I'm just wondering. Yeah, because it's a very low-level threshold sort of burden. I've seen it defined, and unfortunately, I don't have the site of where I've seen it defined. It might be somewhere in the regulations. And what I have is a collection of facts, knowledge, or observations viewed in light of circumstances and the credibility of the information, which would lead one, it's exactly what you just said, which would lead one to conclude that abuse or neglect has occurred. Very low level. Keep that in mind when we talk later on about this same term, reasonable cause. So if you're a mandated reporter, you're going to immediately call and then follow up with a written report. So again, all 51A is just a reporting statute. That's it. So we basically then, actually I want to say something about 51A, and I can't remember if I said it the other day or not. Both 51A and I think it's 51D. And I want you to keep this in mind for when we do the child sexual abuse assignment next week. Talk about instances where, and these are the much more serious instances of abuse. If a child dies, if a child suffers brain damage, if a child's been sexually assaulted, then the district attorney, I'll put this sort of to the side somewhere, gets 51As, the 51Bs, service plans. Okay. So again, this isn't for every case because the Department of Children and Families is set up to, help families, protect children, but it's not an agency like the district attorney's office, whose goal is, punishment, perhaps rehabilitation, but for the most part, punishment. So keep that in mind. In the more serious cases, the department has to, according to 119, submit copies of these reports and service plans as well to the district attorney's office, and that's actually in 51D. So just note that as an aside. We'll talk about that more when we do the sexual abuse case. Hopefully next week we'll start getting into that. So as I mentioned, 51A is just a reporting statute. So if the report, now let's talk about if the different ways the report can come in. So now we've got, so purpose was in the CMRs, reporting 51A, and now duties of DCF, 51B. And it depends on how the report is screened in. Okay. Obviously, it could be screened out, and I mentioned that could be, it could have been, multiple reports. Oh yeah, we already know this, we're already working on it, etc. Or it could be somebody that's not a caretaker, but let's just assume it gets screened in. So if it gets screened in, Amanda Phillips, there's two choices, right? There's two choices as to how it gets screened in. What are the two choices? So you've got the mandated reporter calling in, saying, blah, 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 I saw this kid, he was covered with bruises, blah, blah, blah. I think it was the mother beat him up. So the mother's a caretaker, so it's going to get screened in. But the decision could go either way, and depending on how it's screened in is how quickly the department's going to go, right? What are the choices? I just called you and I said, I went to this house, the kid is bleeding profusely, and mother's saying she's going to kill him. What are you going to do?
So then
And you're just the caller, the answer on the hotline.
they decide whether to act on it or not.
To act on it, certainly, but how are you going to act on it?
Get the police involved. They call them.
Why are you getting the police involved? Maybe the police already are involved. Maybe it's the police that called you, right? Like in that example.
Whether you're going to take the kids out or not.
Okay. Before you make that determination, you're not making the determination. Jonathan? Did you hear that?
Doesn't it automatically get screened in as an emergency?
Okay, but it does, and so those are the choices. It's either an emergency, or it could also be screened in and be a non-emergency, right? So Amanda, you would jump in too far ahead there with your answer. That's okay. So if it's an emergency, we want to be looking at 51B, right? If it's an emergency, how quickly does a DCF worker have to arrive at home or wherever it is? Like, Jim?
It was 2 hours.
Yep. So obviously it's the emergency, 2 hours, and then if it's a non-emergency, how long do they have?
72.
A non-emergency?
2 days.
2 days, so it's the 2 and 2. 2 hours, 2 days. Now this 51B worker that goes out is the 51B investigator. So they're not only going out and talking to people and determining what to do, but then they're writing a report, right? And so if it was the emergency report, that has to be done. They're out there in 2 hours, and the report itself has to be finished in how long? Laura?
Initial in 2 days and final in 5.
What are you looking at?
I'm looking at my notes from 50.
I think you were giving us the non-emergency when you said that. Was she?
It's within 24 hours, isn't it?
Yep.
Yeah, 2 days.
Emergency is going to happen right away. Again, 2 hours, the report is done in 20, I'm sorry, did I say 24 days? 24 hours? And Laura, what did you just say? Because that was for the non-emergency, right?
And the
I always
non-emergency,
forget myself. Oh, it's much longer,
I
right?
was actually doing the math wrong. So non-emergency, start in 2 days and the report's in 15 days.
Yes, 15 days.
24 hours.
So you have almost 2 weeks, a little, actually, 2 weeks and a day. If it's a non-emergency, you're going to start in a couple of days, but you have a longer time to finish your report if it's a non-emergency. So, again, this is in 51B, Section A, Section B, and Section B talks about, you know, what the DCF worker should be doing. Obviously, the home visit, figure out the cause, the identity of people, the condition of the household, any pertinent factor that goes to the abuse or the neglect. Now, C goes to the standard relative to the emergency, right? Everybody's at C. And this is what Amanda mentioned earlier. So what does the worker, again, have to be convinced of if he or she is actually going to take the children with him or her out of the home or out of the situation? Stephanie?
They have to be pretty much convinced that there's a real reason to do something.
What's the test?
The test would be if there's a reasonable suspicion.
You got the word reasonable right. It's
Oh, I'm
Again?
sorry. If there's a reason to believe that
it's
all-
reasonable cause again.
reasonable cause.
Yeah,
for
so
all the
just like
facts
the, I'm sorry not to interrupt, but just like the mandated reporter had to have reasonable cause to believe abuse and neglect occurred. Now what the statute is proposing, mandating the same test, right? The same sort of burden for the worker that's going to make the determination to take the kids out of the home. Reasonable cause to believe, as you just said, is the children's, health, safety, etc., is in danger. But same language again, and you're going to see this again a few more times. This reasonable cause test. Okay, everybody following me so far? So we're still at a situation where there's an emergency, and worker decides to remove the children. Just as an aside too, at this point, suppose that, it's Friday night and it's like a real domestic situation like we talked about before. So worker is going to take the children with. If the worker makes this determination, I'm going to get them out of here, the health and safety is in danger, but where do they go? Jim?
I think at first they would initially try to release the child to a family member
Okay, but in my situation, okay.
prior to placement.
Suppose mom's incoherent, or she's yelling at you, or police are trying to restrain everybody. What do you do then? You don't know. You may not have that knowledge on Friday evening, is what I'm saying, right?
Right.
So what would you do?
Well, I guess at that point,
And again, you're a DCF worker, so you're an employee of the department. What might be your mandate? And you may or may not know this. I don't know if it's mentioned in the article that you guys read, but it's in DCF's regulations. Stephanie?
Usually a supervisor or whoever you're higher up is notified, but there usually is a foster family respite on call at all times, so that you have a list of
Exactly.
that you can call so that the child can go there.
Exactly. Now, suppose that what Jim said was true. Suppose that mom said, call my sister Jean, please. I know you're taking my children, but call Jean. She lives in the next town over. The kids could go to the same school while, I lose whatever, blah, blah, blah. And yet, worker still places in the emergency foster home.
You're blanking on my name.
I'm sorry. I meant to tell you guys that I'm not in 100% today. Jonathan knows because I told him in class I had a really bad bout of vertigo, and I had a chair treatment this morning that made me even so I could be dizzy. There might be some memory loss there.
It's Nicole.
Nicole, I knew that.
Doesn't DCF have to contact any form of kinship placement, anybody who would be willing to take
Yes.
it within 24 hours after removal?
Yes, so there's this, now granted, in the situation I just gave, it could be that it's in the height of the moment, blah, 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 but ultimately, that's what they have to do. And if the kinship is ready, willing, and able, if they pass in terms of, for example, suppose Aunt Jean had, multiple 51As herself, obviously she wouldn't be a proper placement. But if in fact, and if suppose you represent the mom, and she says to you amongst other things, I told them about my sister Jean, but the kids are still in this foster home. Well, you had two cases to read for today, the Isaac and Jeremy cases that would be very helpful. So remember I said I was going to mention cases while we talk about this. Isaac, they're companion cases. Yeah, it was on the reading, right? Isaac and Jeremy?
Oh, yeah.
Yeah, care and protection of Isaac, care and protection of Jeremy. Just basically, somebody just quickly give me the lowdown on, just really briefly in the Isaac and Jeremy cases. And they're similar because one dealt with permanent custody, one dealt with temporary custody, but really the idea, the holding was the same. John?
In Isaac, they asked whether a judge can order DSS to provide a specific placement and specific staffing level for a child who's been adjudicated to be in need of care and protection.
Yep.
And they held no, and it was remanded to the...
And what's the reason why the judge couldn't do something like this?
I believe it violated due process rights of the Constitution.
Violated something. But so think in terms of, I've been talking about DCF being an agency. And remember, I think we did mention last time under the definitional section 21, the definition of custody was that whoever gets custody, in this case DCF, can control the place of abode, control visitation, engage in contracts. And pretty much DCF becomes the parent, right? And can make these custody decisions. So the judge, by the judge saying kid should go there, the judge is actually violating separation of powers, right? DCF is agency, has custody. DCF has the judgment call, because DCF has custody like a parent would, and quote, knows best as parent patriae where the kid should be. And the judge making this direct order is actually violating separation of powers principle by doing that. But what the cases are actually used for is that it's possible that DCF, having custody, still is violating the law, right?
So, right.
So, go ahead.
It had to do with if they were abusing their discretion.
Exactly. Yeah.
And if
So,
they just made an arbitrary decision.
exactly. So in the scenario that I just gave you, DCF would be violating its regulations by not putting the kid with Auntie Jean, all right? And so in that case, a judge could intervene if it was brought to the judge's attention. We now call them abuse of discretion motions. And usually parents and or children file them when they believe that DCF is not following what it's supposed to be following. And it usually deals with custody, visitation, placement, those kinds of issues. So that's what the importance of Isaac and Jeremy is today. Normally, you leave it to DCF, but if DCF is abusing its discretion, basically not following the law, you can still appeal to the judge. The judge in that point could intervene because they're not following the law and could correct the situation. Yeah.
So I just have a quick question. I think I'm getting confused. So when the child is removed...
Yeah, we'll come back to that. I just wanted to sort of on a side, and the issue that I'm talking about, you would be dealing with a little bit later on.
Okay.
Okay? I mean, it might be early to do. I mean, you could bring an abuse of discretion motion whenever you want, but whenever it's brought, to your attention, you would have your motion, you have to have the memorandum, you have to have mom, signing an affidavit on Jean getting involved, saying, I spoke to the department, I've called the department multiple times, it's been a week, they're still in foster care, we don't know what's going on, right? And then DCF would have its argument as to why they're not with Aunt Jean. So it's a motion that you file really from any time the case, and because we haven't gotten to that part yet. Obviously, you have to have an ongoing care and protection case for that. If you have, because the situation we're talking about, the children were taken on an emergency basis Friday evening, and because they were taken on an emergency basis Friday evening, what does DCF have to do Monday morning?
They have to file for a hearing.
Yeah, so they have to actually file the petition under 11924 the next business day. So it's 51B telling you have to do it. So we were looking at 51B, that was the department's, responsibility. Emergency, I went in and took the kids, but again, I don't have custody. Parents normally have custody, so that means the next business day I'm going to be looking to get custody from the court.
And that's just the order of temporary custody, not
yes,
permanent.
yeah. We're going to talk about that actually right now. So what you want to do now is you want to go back from 51B to 11924, because 11924 is the beginning of a care and protection process.
You said the other day that it doesn't have to be DCF, it could be anybody that
I
files.
was just going to say that. You notice the very first word under 11924 is a person may petition. I mean, most of the cases that you're dealing with in juvenile court, CMP cases, DCF happens to be the person, but the statute is written so that any person could actually file a care protection case. And that very first paragraph that has the sections A, B, C, D, those are the jurisdictional basis for filing a care and protection petition. You have to allege somehow that children are without, necessary, care, that they're growing up, with conditions damaging to their character, that a parent is unable, unwilling, incompetent. So it's going to cover because it's phrased so generally, it's going to cover every possible scenario of abuse or neglect, physical abuse, emotional, domestic violence, child sexual abuse, even the cases of medical neglect. When I say medical neglect, it doesn't necessarily denote neglect. It means that a party is seeking, and that party might be DCF, it might be somebody else, is seeking to have medical care done for a child over the parent's objection, be it religious or whatever. So it includes all those situations. So that, again, that first paragraph of 11924 are the allegations. So the worker would be going in with her petition, with her affidavit, and if you jump down to the the third and fourth paragraph talk about the emergency hearing. The second is notice, and I'll come back to that in a minute. But if you look at the third paragraph, you're seeing a test again, similar to what we saw over here. So there's the judge, and normally it's the judge and the social worker. It's emergency nature. You're in there the next morning. Parties may know about it by then, but they're not necessarily there. Even attorneys are not even appointed yet. They're going to get appointed now. Even the DCF attorney's not going to really know anything about the case yet. It's the social worker that does. So it's the social worker and the judge with his or her petition and affidavit. And Stephanie mentioned temporary custody. What does the judge now have to be convinced of to give DCF temporary custody under 11924?
They have to be convinced that there is
Give me the magic words again.
reasonable cause.
Yes. Reasonable cause again. So the test of the emergency hearing, this is the emergency hearing. This is it. It's right in the statute itself. It's in 11924. Very, like I said before, low threshold burden of proof. The court satisfied, petition attested, social work under oath, blah, blah, blah. Reasonable cause to believe that children are suffering from serious abuse and neglect, and that removal was necessary for their own safety. So you get temporary custody. On that day, you're going to have the Section 21 and 21A talks about the court-appointed investigator. You're going to have the attorney, the counsel appointed. Now, court-appointed investigator, which we'll also talk about, is a person that's on no one's side, not a department employee, not there for the children, not there for the parents, an objective person that's done the training for court investigations, sort of an arm of the court. I mean, the judge doesn't have time to go out his or herself to talk to the parties, to come up with, these are the facts. This is what happened that led to the removal, that leads to the petitioner asking for custody, along with perhaps recommendations or not. That investigator also becomes, if you look at 21A, the investigator is what's called a qualified expert. And this is one of the instances where, even though the statute says the CP cases are just like any other case in Massachusetts, according to the rules of evidence, blah, 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 you sometimes see exceptions, you sometimes see relaxation, and it goes to the informal nature of the juvenile court. So the person that writes this report, and this isn't going to be right away, so when we get to the 72-hour hearing, you don't have the investigator's report yet. That usually comes out, the earliest is about 6 weeks. So that investigator, as I said, becomes a qualified expert. That person will be testifying at trial. That investigative report may contain hearsay that attorneys sometimes fight about, looking for to strike portions of the investigator's report that contain perhaps, opinions that are inadmissible for one reason or other. The investigator may not have the expertise to make that sort of opinion. That investigator may be citing in their report other people saying something, which is out of court statement, offered in evidence, right? Prove the truth of the matter asserted. But the case law has allowed hearsay in the investigators, as long as they can get to their sources, as long as they can qualify that they've got the facts by talking to these particular sources. So for the most part, investigators' reports usually get in, and the investigator is subject to cross-examination by all the parties. So that's the investigator, gets appointed right off the bat, really doesn't get involved for another month or so. So things are still happening in that first month or so. Attorneys get appointed, attorneys for a dad. If there's more than one dad, attorneys, dad one, dad two, whatever. Attorney for mom, especially, and for the most part, you usually do see a separate attorney for mother and a separate attorney for father in many of the care and protection petitions, just because of the nature of what has occurred, because you sometimes, or most of the time, have an offending spouse and a non-offending spouse, depending on, the situation. Children get counsel. Remember, this all goes back to Galt, right? They're losing, parents are losing custody, liberty right, the 14th Amendment that we talked about, so they get counsel, even though it's not a criminal case, it's a civil case, but parents get counsel per the statute in Massachusetts in Section 29. Children get counsel too, for the same sort of reason. Remember that I said that Galt was the wellspring for children's rights, and because of Galt, that's how we've come so much forward from Galt. Children, there could be child 1, child 2, child 3, and child 1 and 2 might have sort of similar interests. Child 3 might have different. In many cases, you're going to see different counsel for different children. Didn't happen in the old days when I was representing them. It was a mess. So for the most part, when you walk in to juvenile court and there's a care and protection case being heard, some of the courtrooms are really small. It can get really crowded because you have all of these attorneys. I didn't mention a guardian ad litem because that sometimes happens as well. In the sexual abuse case you start looking at next week, there was a guardian ad litem for the children because the children had recanted immediately, said they wanted to, return home to their dad. There were serious allegations. So bottom line is you might have a GAL, you might have, 2 attorneys for 2 children, you might have 2 attorneys for 2 dads, attorney for mom, DCF attorney, the social worker, not to mention the court personnel in the room. You had a question, Nicole?
No,
I remember your
no.
name. Oh, somebody had their hand up.
No, I.
Oh, okay.
But you answered it.
Yeah.
Oh, okay. So we're still on that first day, right? DCF gets custody, appointments, blah, 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 and we're still looking at 11924, because what happens next? You would have temporary custody as DCF after this emergency removal, but only for?
Isn't a date set for a 72-hour hearing?
Only for 72 hours, okay? Which may or may not happen in 72 hours. And there may be varying reasons for that. You might have stipulations by the parties. You know what, let's let DCF have custody. We don't want the judge to hear this damaging information now. We'll try to get our act together. Or counsel, I just got to talk to my client. We need more time to prepare. So there may be various reasons why the 72-hour hearing doesn't occur in 72 hours. It's still called the 72-hour hearing, even if it occurs a month later or 2 or more. What's the standard? Now, DCF still has custody at the 72-hour hearing. DCF is still the petitioner, so DCF still has the burden of proof. And where does that burden of proof come from? Now, this is from case law, Joe.
Robert.
The Robert case. And what is it?
Preponderance of the evidence.
Yep.
That the child will be in danger, goes back to
Yep. So now we're upping the ante here. It went from, you only have to show reasonable cause, the kids are in danger, it's an emergency. Now, you have to show, you know what, to continue custody with DCF, DCF has to meet its burden of preponderance of the evidence. One of my very good associates who represents frequently mothers, fathers, children, but mothers probably more of the time. For whatever reason, the court appoints her for mothers a lot. Has a very high rate of winning 72-hour hearings. I always say it's because she's so good. She always says because she only takes the 72-hour hearings to trial that she knows are winnable. So, you know, you're advising as an advocate, as a lawyer, you're also advising your clients as well. You know what? We're not going to meet this burden now. Why go to a hearing and go through all this crap that the judge is going to hear? And for the most part, usually the care and protection cases are retained by the same judges. So why have the judge hear this all now when maybe you'll have some time to sort of get your act together? So again, as I mentioned before, for one reason or another, you might not actually have a 72-hour hearing. In any event, whether you stipulate or whether DCF wins, custody remains with DCF if, according to the Robert case, they prove their burden by preponderance. Laura?
So if she had a client and she recommended not going through with the 72-hour hearing, do the children just go back home?
No. They stay with DCF. They stay with DCF. And ultimately, of course, it's up to your client. You're advising someone who's, you know, mature enough and competent enough, and those are other issues because you might have not maturity and no competence, and then you're getting into jail issues and whatnot. But even if you believe as an attorney that this case is not winnable, same thing happens in criminal law, right? The client says to you, no, I want to go forward. Then you're going to go forward and do the best you can, right? That's all you can do.
Yeah, I think I meant the revert. I said it incorrectly.
Oh, okay.
So they decide.
If you're a parent and you're waiving the 72-hour hearing, right?
Yeah.
Custody remains with DCF. Remember, one of the cases you have to read for today was Manuel. It was a little bit different, but it was the kid that waived the first. Remember, the kid waived the first 72-hour hearing, and later on there was a big to-do with the aunt that had the kids, and then there was another hearing coming up, and the kid, you know, the argument was, well, you waived your right to a 72-hour hearing, and the court ended up saying is no, not only did you not waive the right to the 72-hour hearing, the hearing again concerns custody to the department or custody to, you know, a person like the grandparents that he was proposing. And so today we have, sometimes it's called a Manuel hearing. You might hear attorneys saying, I have a Manuel hearing coming up. Well, Manuel hearing is nothing more than a custody hearing itself in which a party is actually proposing a placement, you know, a grandparent, an aunt, etc.
So essentially, if you do challenge the 72-hour hearing and you're able to show, but the state isn't able to show.
Yeah, the state, that's the important thing, right?
Then the kids would go back to the parents. If they can't meet
if the
that
state
burden, the
doesn't
kids
meet
go
its
back.
burden, you've won.
But that doesn't mean it's over. It just means that initial hearing.
Well, it depends. For the most part, it usually is over.
Okay.
Yeah, but case-by-case basis on that. Yeah, but for the most part, it's over. Yeah, and remember what you just said too. Parent doesn't have to prove anything. It's the department that has to meet its burden. Of course, by saying that, this is still, it's not a criminal case. So you know how in a criminal case, if you don't take the stand, that means nothing, right? In fact, it's a violation of constitutional right if somebody somehow uses that. In a care and protection case, if a parent doesn't take the stand, it's actually an inference of unfitness. It can't be the only reason the judge would, you know, rule against you, but it's one of the factors. So by saying it's the department's burden, it doesn't necessarily mean that the parents don't have to do anything, you know. unless the department's case is so flimsy, then maybe you don't have to do anything. For the most part, I've seen the 72-hour hearings that get won by parents when parents are there, parents testify, they have others, etc. And at the same time, when the department has, not much as a case. You've worked with, or you've met my associate DeFilippis, and Chris Cook also teaches here. He's a department employee. They have this case, and it started with an infant death. Turned out it was a SIDS case, but there were other kids. So infant death, police get called, blah, 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 they're mandated reporters. They come in and talking to mom and dad. Of course, mom and dad are devastated. There's 2 other little kids. Well, dad was like on the most wanted list. There were warrants and whatnot again. So he had to clean that up. But at the same time, DCF took emergency custody. And there was, and it was nice because they immediately did go to their aunt's aunt who actually lived on the South Shore. Aunt brought them up for the funeral, etc. Well, we get to the 72-hour hearing, and really, first of all, the cause of the infant's death wasn't anything parents did. Parents were perfectly appropriate with the kids. Yes, dad had a criminal record and a bunch of defaults. He actually cleared them up by the time we went to the 72-hour hearing, because the 72-hour hearing was much later than 72 hours. So he had time to clean that up. And mom had some drug, so there was some stuff that was negative, but not enough for DCF to have custody. So case immediately over, preparations for children to be returned. So in that case, the case ended. So you could win, again, you're an attorney, you're advising, you're trying to figure out what the best, but at the end, it's also the client's decision whether to go forward or not. Nicole?
I have a question on the 72-hour hearing. We take in foster children in my house, and
you mentioned that.
Yeah, and we had a sibling group that came in, and their parents showed up to the 72-hour hearing and said, do what you want with them, we don't want them. So everything moved a lot faster. Now,
when you say parents had counsel.
Parents had counsel.
And did they sign stipulations or anything? You probably didn't know because you weren't a direct part of it, right?
Yeah, no, I was just at my house. But, the social worker told my parents that, this could either become a long-term placement or we're going to move them to pre-adoptive, because in the 72-hour hearing, the parents just stated, we're done. This is their chance to go out and do what they want to do, so they said, you can have them. So everything moved a lot faster. Now, what would have had to have happened in that courtroom in order for that to, 72 hours, that's pretty instant for a parent to have just had their children removed and then to say, we decided we don't want them anymore. How does that even happen?
Well, you heard it that way, but again, it could have been different. It could have been that, parent has realized how hopeless his or her situation is right now. And maybe, again, was advised by his or her attorney, you go to trial, and this is a mini trial. This is not the end of it, usually, but it's like a trial. You can present whatever evidence you want, etc. So they may have decided that, we're going to lose if we do this now, and they may have, issues.
Right, some parents suck. They might have they may have already known before any of this even happened.
Yeah.
They didn't want their kids, and like you said, sort of saw this as, hey, this is our chance to get rid of them and go do what we want to do. Or maybe the attorney said, you got to stop doing drugs, you got to do this, and they might have said, no, my heroin's more important to me than my kids.
I want to say something before I forget about the notice requirement that's also in 11924, and I may or may not have mentioned it before, but so the parents get notice, obviously, of the camera. They're going to get notice. They're going to get ability to have counsel appointed and all that. But the notice, it's a big paragraph there in 11924. In the middle of the paragraph, it says, the summonses shall include notice that the court may dispense with the right of the parents to notice of or consent to the adoption of the children. So that's pretty serious. And that pre-1994, that wasn't in the statute before, and it was purely a care and protection case, meaning that the worst case scenario when these cases went to trial was that a parent would lose custody, the case would still remain open, and you would have 29B is another section of 119, and the 29B are annual reviews. And actually 26, and I'm going to mention this in a second because that's the trial. Section 26 also has a review procedure called review and redetermination. So what would happen is, case went to trial. The case was over. Children were judged in need of care and protection under Section 26. That's the final hearing. And 6 months later, you could have a parent or even a child petitioning the court for what's called a review and redetermination. Something new has happened. I've been getting treatment. If I have drug alcohol issues, whatever, I want to get custody back. Because the idea was that under care and protection that parents' rights were never terminated. They just lost custody. Okay? And then there was this big clamor, oh, kids are in foster care for so long, and we have situations where parents never can get their act together. Because what would happen is when DCF has goals in these service plans that I haven't even come to that point yet, but DCF's goal, in most cases at least initially, is reunification. Let's see what services can we offer so that this family can become intact again. Sometimes, again, depending on the situation, the children, the parents, DCF changes its goal to termination of parental rights. What the state had to do, and we're going to deal with this really after vacation when we get to the adoption cases, but what the state used to do then was if DCF changed its goal to adoption, they had to go to probate and family court. Now, the care and protection cases are heard in juvenile court. They had to go to probate and family court and file a new petition under Chapter 210, Section 3 to get parents' consent to adoption dispensed with. And where that test then became the best interest of the child. And there were a list of 14 factors, there still is, that dealt with, child has been in foster care, a certain number of months or years, parents haven't followed services, there's been this, terrible abuse that has occurred, repetitive nature, parents have been offered services and haven't taken them, things like that. And then also, sometimes you had different attorneys appointed. So you had the attorneys of the care and protection case in juvenile court, and when DCF filed its petition under 210, you had different attorneys sometimes representing, so it became this big mess. Legislature decided to change the statute to allow that it could happen in certain, drastic instances that the juvenile court could, as a result of the care and protection case going to trial, as a result of DCF saying we want termination, could dispense with parents' consent to adoption. Frankly, I think that it made the proceedings much more adversarial. Parent is getting that notice right from the beginning, instead of getting what used to be an agency, it was called DSS before, that's going, a social agency that's going to try and help parents. Granted, you might lose custody, but it didn't mean forever, et cetera, et cetera. Now you're getting this notice from the beginning, and all you want to do is fight DCF. But either way, you have problems, but that's what it is. So let's actually turn to 26 because that's the trial. And notice in the first paragraph of 26, it says if the child is identified by the court. Now, I think I mentioned this before. This isn't like an ordinary, like a civil case or a criminal case where, the child is a party and has to appear all the time, or a CRA, what used to be a CHINS case, etc. This is a case where parents, even though it's a case about a child, is care and protection of, Laura Lowry. Okay, or the Lowry children, etc. Even though the kids are parties, you don't normally see the kids in the hearings themselves. But they have to be identified at least once by the court, and that's what this first section of 26. The child is identified, blah, 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 and we go forward.
I think the other day you even said sometimes the judge has to go to the hospital to see the child.
Exactly.
If they can't come.
Exactly. Now, just like the 72-hour hearing and the Robert case setting the standard for preponderance of the evidence, what's the standard for the trial of the CMPs, and where do we get that from? Anybody know? It's in your cases that you have to read for today. So we finally go to trial. Remember, it keeps going up because now the parents are in danger of losing custody forever or maybe parental rights. So it should be higher than preponderance, right, Laura?
Yeah, clear and convincing.
Yeah. So for trial, the petitioner has to show clear and convincing evidence of current parental unfitness. And what's the U.S. case that set the standard, and then Mass obviously followed as well?
U.S. was U.S. was Santosky v. Kramer.
Yeah. So it's the Santosky case, clear and convincing evidence. Notice I emphasize current. So under 26, one of the problems with the statute before too is that children were in foster care forever. You know, parents didn't have custody, but they continued to have visitation now and then, and so the idea was, when the legislature, rewrote the statute, to get these cases to trial as soon as possible. So under 26, again, just like 72 hours, the CNP trial is supposed to happen within 15 months, which is not a long time, within 15 months of the start of the petition. So notice it says, again, so by the time of trial, whatever issues parents had, they have to be currently fit, or else the children are going to be what's called adjudged, the adjudication part, in need of care and protection. And that's what we look to the case law for, what does current parental unfitness mean? And it could be a number of things, but it can't be some things by themselves. So for example, it can't be just the messy house. It can't be just the drug dependence, right? It has to be how that fitness or unfitness relates to your children, the relationship itself. So that would be the adjudication part. And if you continue on in section 26, sort of, if the kids are adjudged in need of care and protection because parent is supposedly currently unfit, the least actually restrictive alternative, if you look at 119.26 subsection 1 under B, it may permit the child to remain with the parent. So that could happen. Transfer custody to someone else, another agency, or most likely under Roman numeral 3, the Department of Children and Families, and then appropriate physical and dental care. And then the worst case scenario is the termination of parental rights pursuant to. And so if you look at 119.26 now, it intersects with the adoption statute, 210 section 3, which we're going to deal with in more detail when we look at the actual adoption cases. But know that that's the worst case scenario now. So if that happened, these reviews that I talked about before, annual review, not going to happen because there's no more care and protection case. It's over. Parents have lost, parental rights. The review and redetermination, the annual reviews, that doesn't happen. Let me just go back for a moment because I jumped over to the start of a care and protection case if it was an emergency. And I also wanted to say that if you go back to 51B, as a result of this investigation, right, whether it's an emergency or not, the 51B investigator, the social worker, has to make a determination, right? And it relates back to that first 51A report. So the social worker could find that there was no reasonable cause, right, to believe abuse or neglect occurred, and the thing could end there. Or, and most of the cases are, and it's the test again. Social worker, at the end of the 51B report, finds, again, reasonable cause to believe the children, that the report of neglect or abuse occurred. And as a result of that, now the 51B worker just did kind of a short investigation. So now you have the department involved, and they have to do an assessment, which is a longer sort of look at the family. And that takes a long time. It takes up to 45 days assessment. And then after that, 10 more days is the service plan that I mentioned before. So you're talking about at least 55 days after a 51A report comes in, you have DCF coming up with this first service plan. This is the situation, this is the family, this is what we're going to do for the family, these are the tasks mom needs to do, dad needs to do, etc. But if it's 55 days later, remember that if there's court stuff going on, it's going on at the same time. So keep that in mind. Or you might not have any. If it was a non-emergency, say it was a non-emergency, right? Kids weren't taken, but 51B investigation happens, worker finds reasonable cause, worker says, okay, then the assessment worker gets involved, assesses the situation, comes up with a service plan. You may have that happening and no court involvement because DCF hasn't made that decision. And that could happen for a while, for years. So don't think just because you have a 51A report and a 51B investigation that there has to be a care and protection case. So, sometimes people get mixed up. Yeah.
Could you just clarify one thing? So back on the care and protection side of the board. All right, so the 72-hour hearing, let's say it is one of these rare cases where the parents say, we don't want nothing to do with these kids, blah, 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 whatever. For the judge to take away their rights as, like, for adoption, does it then rise to the level of clear and convincing evidence?
No, you're now talking about stipulations that might happen along the way.
Okay.
Right? So you might have a stipulation, 72 is still temporary custody.
Right.
Case still remains open. DCF still offering services. The other thing is, remember I mentioned Section 21 and the qualified experts? There's another person that's called under the statute of qualified expert, and that's a DCF worker working with the family. So between the 72-hour hearing and the final trial, it doesn't mean that you're never in court. Okay? So regardless of, even if there isn't an abuse of discretion motion or any kind of motions, so after the 72-hour hearing, the court will say, okay, parties can go, case is back in, March 25th. Come back in on March 25th, the social worker is going to submit this report to the court, give all parties, and you never get it ahead of time. You get it that day. The attorneys are reading this report of the social worker that contains all kinds of damage and information about their clients. And there used to be a big uproar about this. One of the cases that you read from today, Bruce, says that not only will that, that report come in, it can contain hearsay, again, as long as the sources, are reputable sources, blah, 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 as long as, there isn't sort of opinion, stuff that, could be omitted, that DCF worker becomes a qualified expert, and the court is getting these reports. It could be almost on a monthly basis. It depends how crazy this case is, that it might continue for another month or 2 months, or et cetera. So while that's happening, you might have at some point parents, for whatever reason, saying they're going to agree, right? They're going to step. DCF may have changed its goal to adoption. DCF may propose to parents. I think Nicole had this case, a case like this. DCF may propose to parents, look, if we terminate, you can have your letter and your Christmas card once a year, or, we can have this like sort of open adoption kind of thing. And they,
okay.
For whatever reason,
they can agree to the waiving the right to prevent the adoption. But if the judge is going to find that against maybe their agreement, it then rises to the level of clear and convincing that they're currently unfit.
If you have a trial. Now remember, just with any...
where the judge can take away their right to prevent adoption without meeting that burden of clear and convincing.
Okay, think of it with any case when there's no agreement, right? When there's no agreement, there's going to be a hearing of some sort, right? So if there's no agreement, you're going to get your full-fledged trial. And in the full-fledged trial, judge has to find, and it's the department's burden, that parents are currently unfit, okay? There wouldn't be a trial if parent is stipulating.
Okay.
There wouldn't be a trial if, say the CMP, and I haven't even talked about this at all, but this happens sometimes as well. CMP gets dismissed because, you know, a relative has filed the guardianship, everybody's okay with that. Yeah. In terms of parental rights, I mentioned the, you know, right to have DCF not abuse its discretion relative to placement. As long as your rights haven't been terminated, you also have visitation rights, right? What's the custody of a minor case that I had you read for today?
Minor case?
And it talks about visitation. So when, in what situation can DCF having custody say, we're not going to let parents see this kid? What does DCF have to do? So suppose you represent mom or dad and they're calling you, and in between, you know, your status hearing isn't for another month, and parent is saying, I'm not getting visits. Can DCF do that?
I think they can. This case says that they can. I think depending on the situation, this was the one.
What do they have to do? If DCF really, you know, has that goal, has that purpose, you know what, we need to suspend visitation because blah, 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 blah. What does DCF have to do under the custody of a minor case?
They have to go back to court to suspend those.
To go back to court to do what?
To ask for a temporary suspension of visitation.
Yes, and what's the standard? I'm going to see if I mentioned all the cases because we're running out of time. What's the standard for termination of visitation?
I would guess that it would be.
Well, you guess it's right in custody of a minor.
Oh, okay.
So you really don't have to guess.
Current parental fitness?
No, that's to, current parental fitness is to lose your rights altogether, to lose your custody rights. So you could be unfit, but because your parental rights have not been terminated, you should have the right to visit your child. Because remember, these children are going to be without seeing you for a couple of years by the time your case goes to trial, right?
Demonstrating parental visits will harm the child or public welfare.
And that's the thing. DCF can't just decide on its own in the service plan, oh, you know what, you're not going to see your kid. They have to go to court to terminate visitation. And many times, and that's another abuse of discretion kind of motion. And many times parents don't get it. They think that, you know, DCF can do this. They might not be happy with it. And you have to remember, too, you might be appointed as counsel, but things are going on within the agency as well that you should be aware of, either through your client or through communication with the agency. Because an agency determination does not mean that that's the end of it. If you're an aggrieved party of any kind of agency determination, the Administrative Procedure Act, Chapter 38 of the, nothing to do with 119, any administrative agency, you can appeal any decision. So back here, in fact, when we do the medical neglect, you're going to read the Cobble case later on. When the 51B investigator comes back, and you're going to get that report as the parent too, and says that, you know what, the 51A, I'm supporting the 51A report. It's called substantiated or support. They keep changing the language. I'm supporting it because there's reasonable cause to believe your kids, you know, you've abused your kids, or you neglected your kids. Okay? Many lay people don't realize they can appeal that. Now, granted, it's an appeal to the agency, but Cobble ended up taking, and I'm not going to talk about Cobble because you're going to read it, all the way up to the SJC. So you've heard the term exhaust administrative remedies, right? So anything that goes on here relative to DCF, parent still has rights. But you know what? This is the sad thing too. If there's no care and protection case, you don't have lawyers over here relative to DCF unless a parent on his or her own hires a lawyer. There's no right to a lawyer when DCF finds it's reasonable cause under 51B. You don't have a right to a lawyer, to an appointed lawyer. Certainly, you can hire a lawyer. You can say, I want to appeal. It's under the, judicial, not the it's a quasi-judicial, power of DCF. The fair hearings is what they're called. So you can ask for a fair hearing. Even a layperson, you don't even need a lawyer, but not all lay people know that they can do that. So again, this is like basic review of the care and protection process, as well as DCF's pre-court investigation, as well as sort of their process of following their regulations, coming up with a service plan. And by the way, that service plan that comes out in 55 days, 6 months later, there might be a need to do a new service plan. So you'll see service plans coming out, periodically, as long as the case remains open. So we'll start on Tuesday. Actually, Tuesday we'll do domestic violence. I'm going to put together for you this the child sexual abuse packet, and what I'll do is I'm going to take a look, because there's quite a few of the child sexual abuse cases that I want you to read, and some are juvenile court, like C&P type cases. Some are criminal cases. So let me hold off if you want to go ahead. I'll tell you which ones I'd like you to read, because what we're going to do is get involved with this case study with roles, etc. But I'd like you to read certain cases before we start the case study. So I'm hoping we can start the case study by next Thursday. But I'll let you know which.
Hold off on reading ahead then?
Yeah, so just read the domestic violence for Tuesday. Did you have questions?
No.
No.
I was just confused. But
Yeah.
Yeah, the discuss domestic violence questions, is that?
Yeah, so just read that section of the syllabus for Tuesday. And my plan is to, and what I usually do now, this is actually a packet, so I'll hand it out to you on Thursday. On Tuesday. I'll hand it to you on Tuesday, and I'll either send an email or we'll talk on Tuesday as to what cases you should be reading for Thursday. Okay?
And the packet you're going to give us encompasses
everything.
The next 2 days worth of.
Yeah, really the next week and a half after that. Okay? Thank you.